All right, so up to this point, we have spent a good deal of time discussing how crimes are committed, what elements prosecutors must prove, and how criminal liability is established. Okay, so this chapter shifts our focus in a different direction because now we're going to examine situations where a defendant may avoid criminal responsibility entirely, okay? Or they can reduce their criminal liability through the use of defenses, okay? Now, this chapter is one of the most fascinating in criminal law, if you ask me, because it forces us to confront a very basic question that even if someone committed the act, should society still punish that person? And the answer is not always yes, okay? Criminal law recognizes that there are circumstances where punishment may be inappropriate, it might be unfair or inconsistent with the purposes of the justice system. Okay, so in some situations, a defendant lacked the mental ability to form criminal intent. Okay, in other situations, a defendant acted under threat or extreme necessity or self defense or a mistake. Okay. Sometimes the issue is not whether the act occurred, but whether the law should excuse or justify the conduct. All right. Now, defenses exist because criminal law is not simply concerned with whether an act happened. It is also supposed to be concerned with fairness and responsibility and intent and justice. Okay. So we're going to explore factual defenses, statutory defenses, insanity, duress, necessity, self-defense, intoxication, and a whole bunch of others, okay, that shape how criminal responsibility is determined. And many of those defenses have generated a lot of controversy because they force courts and juries and legislatures and even society themselves to decide who deserves punishment and who does not. Now, before we examine specific defenses, let's first understand what the term defense actually means within criminal law. Okay. A defense is essentially a reason that is offered by the defendant explaining why criminal liability should not be imposed or why punishment should at least be reduced. All right. Sometimes people assume that a defense means that the defendant is claiming that the alleged conduct never happened, and that's not always true. Some defenses directly challenge the prosecution's version of events. Others acknowledge that, yes, the conduct did occur, but they argue that criminal liability should not follow because special circumstances exist. Okay. For example, suppose someone, hits another person during, a fight, okay? They have this physical altercation. So the defendant may admit that the act in fact occurred, all right? But argued that it was committed in self-defense. In that situation, the issue is not whether the punch happened. The issue is whether or not the law considers the conduct legally justified, all right? Criminal law recognizes both complete and partial defenses. Now, a complete defense results in acquittal. So if the defense succeeds, criminal liability is going to be eliminated. Now, a partial defense does not completely excuse the conduct, but it can reduce the level of criminal responsibility. For example, a successful diminished capacity argument might reduce a murder charge to a lesser homicide offense. Why? Because the defendant lacked the mental state that was required for the greater crime. All right. Now, I need you to understand the distinction between factual and statutory. So a factual defense is going to rely on circumstances surrounding the events themselves. You're talking alibi and consent and self-defense. These are all very common examples. Now, a statutory defense, it exists because legislatures created specific legal protections that allow defendants to avoid liability under particular circumstances. All right. And one of the most important principles that you should remember is that defendants are not required to prove their innocence. Under the Fifth Amendment, defendants possess the right to remain silent, and they generally have no obligation to present evidence at all. So the burden remains on the prosecution to prove that guilt beyond a reasonable doubt. All right. And that constitutional principle is going to remain one of the most important protections within the American criminal justice system. Now let's talk about affirmative defenses. And you may recognize these from some of the other classes where they've gotten talked about, but if you have, just take it as a refresher. For those who have not, just know that these operate somewhat differently than ordinary like denials, okay? So an affirmative defense does more than simply argue that the prosecution failed to prove its case. Instead, the defendant introduces additional facts or circumstances that, if true, it justifies, excuses, or it reduces criminal liability. Okay, so affirmative defenses are unique because they partially shift certain responsibilities to the defendant. All right, this does not mean that the prosecution suddenly loses its obligation to prove its guilt. All right, rather, the defendant is going to assume responsibility for introducing evidence to support the defense that's being put forward. The law refers to this as the burden of production. Okay. So the defendant has to prove, they have to present enough evidence to raise the issue legitimately before the court. Now, this burden is usually fairly low. So the defendant does not need to prove the defense immediately. They only need to produce enough evidence to make the defense a genuine issue for consideration. Now, once that occurs, additional questions are going to arise, regarding persuasion. Now, depending on the jurisdiction itself and the particular defense that's involved, the defendant may be required to convince the judge or the jury that the defense is valid under the applicable legal standard. All right. Affirmative defenses often involve matters that are uniquely within the defendant's knowledge. So, for example, insanity, duress, entrapment, self-defense, those frequently depend on information that is unavailable to the prosecution unless the defendant introduces it. All right. And affirmative defenses, they illustrate an important truth about criminal law. And that trials are not always simple contests over whether, the act occurred. The real dispute is going to center on why the act occurred, and again, whether or not the surrounding circumstances justify a different legal outcome. Now, one of the most controversial defenses in law, criminal law rather, is insanity. And few defenses generate more public misunderstanding than insanity. Now, popular culture often portrays the insanity defense as a loophole that allows dangerous offenders to avoid punishment. Okay, now in reality, insanity defenses are used relatively rarely, and they succeed even less frequently. Okay, now at its core, the insanity defense is based on the idea that criminal punishment serves little purpose when an individual lacks the mental capacity necessary to form criminal intent or to understand the nature of their actions. All right, so remember that criminal law generally requires both a guilty act and a guilty mind. So if a defendant's mental condition prevents formation of the required mens rea, then fundamental questions arise regarding moral blameworthiness and criminal responsibility, I should say. Now, this right here says, explains that insanity is a mens rea defense because it directly attacks the mental state component of the criminal liability, right? But you should also distinguish insanity from diminished capacity. These concepts, they are related, but they're not identical. Now, diminished capacity generally argues that the defendant's mental condition prevented formation of a specific mental state that was required for a particular offense. Okay, so if successful, the result may be conviction of a lesser offense rather than a complete acquittal. All right, insanity, by contrast here, is typically a complete defense. And the underlying theory supporting insanity defenses is that criminal punishment serves several goals. We're talking deterrence, retribution, incapacitation, and rehabilitation. So if an individual could not rationally understand or control behavior because of severe mental illness, then many people question whether or not those goals are truly being served by ordinary criminal punishment. All right. And this is where criminal law intersects directly with psychology, psychiatry, philosophy, ethics, all of that. Okay. The question is not simply whether someone committed a harmful act. The question becomes whether that person possessed sufficient mental capacity to be held criminally responsible for it in the first place. So now we need to talk about the most famous insanity test in American criminal law, and that's the Monotone Rule. Now, this test originated from an English case in the 19th century that involved a man named Daniel Monotone. Monotone suffered from severe delusions, and he believed that he was being persecuted by the British government. Now, acting under those delusions, he attempted to assassinate the Prime Minister, but he mistakenly killed the Prime Minister's secretary instead. So that case generated a lot of public attention, and it ultimately led to the courts to develop a legal standard for determining criminal insanity. Okay? So under the Monotone Rule, the focus is on the defendant's ability to understand what was happening at the time of the offense. So the key question is whether mental disease or defect prevented the defendant from understanding the nature and the quality of the act, or from understanding that the act was wrong. This is often called the right-wrong test because it focuses heavily on cognitive awareness. For example, imagine you have a defendant who is suffering from a severe psychotic episode, who genuinely believes that he's squeezing a lemon when he's actually strangling another human. All right, well, under that scenario, the defendant arguably does not understand the nature and the quality of the act that's being performed. All right, but let's consider a different defendant. Let's say that they understand the physical act, but they suffer from a delusion causing them to believe that God has commanded the killing and that the act is morally required rather than wrong. All right. Courts may then have to determine whether or not the defendant truly understood the wrongfulness of the conduct. All right. And this is where these cases become extraordinarily difficult because jurors are often asked to evaluate these mental states that may be far removed from ordinary human experience. All right. Now, the Monotone Rule, it remains influential today because many jurisdictions still continue to use some variation of this approach. Again, the test focuses on, the cognitive aspect, the knowledge, the understanding, and the rational awareness rather than emotional control or impulse. All right. Now, there is a criticism that is frequently raised with, the Monotone Rule, and that is that a person can understand intellectually that an act is wrong while still suffering from a mental illness that is so severe that meaningful self-control is impossible. And that criticism led to the development of additional insanity tests, which we'll discuss next. So as the court struggled with the limitations of the Monotone Rule, you have additional approaches that emerged that were attempting to address situations where defendants understood their actions, but they lacked the ability to control them. One of these approaches became known as the irresistible impulse test. Now, under this theory, a defendant can be considered legally insane if, a mental disease or defect has destroyed the person's ability to control their behavior, even if the defendant understood that the act was wrong. All right. Now, think about this distinction very carefully. The Monotone Rule focuses primarily on whether or not the defendant knew that what was happening and understood the right from wrong aspect of it, right? But the irresistible impulse test focuses on whether or not the defendant possessed sufficient control to resist the criminal act. All right. So, for example, imagine someone suffering from a mental disorder, a severe mental disorder, who fully understands that killing another person is wrong, but experiences an overwhelming, psychological compulsion that is destroying their ability to refrain from acting. So under the irresistible impulse approach, the inability to control the behavior becomes the central issue. All right. And this is where the courts have encountered some very significant difficulties. Because how do we determine whether an impulse was truly irresistible rather than merely unresisted? All right. And that question has challenged courts and psychiatrists and psychologists and legal scholars for decades, and it will continue to do so. Then we also have the Durham Rule, and this represented a dramatic departure from the earlier approaches. This asked whether the criminal act was the product of a mental disease or defect. If the offense would not have occurred but for the mental illness, then the defendant could potentially be found legally insane. So at first glance, this approach sounds relatively straightforward, right? But courts quickly discovered that this test gave enormous power to expert witnesses because the outcome often depended heavily on psychiatric opinions regarding causation. All right. And as a result, many jurisdictions ended up rejecting the Durham approach. And now today, only New Hampshire remains the primary jurisdiction that is still associated with that test. But the history of insanity, law reveals like this ongoing struggle within the legal system. Courts want rules that are supposed to be fair, medically informed and understandable to juries. But achieving all three goals simultaneously has proven to be remarkably difficult. Now we have the model penal code approach, which many scholars view as an attempt to combine the strengths of the earlier test while avoiding some of their weaknesses. So the model penal code test is sometimes called the substantial capacity test. All right. This approach shifts away from that rigid all or nothing thinking. All right. So earlier tests often required courts to determine whether a defendant completely understood right from wrong or they completely lacked control. So the model penal code instead focuses on substantial impairment. Now, under this approach, a defendant may qualify for the insanity defense if a mental disease or defect substantially impaired the ability to appreciate the criminality of conduct, or it substantially impaired the ability to conform their behavior to legal requirements. All right. Now, the word appreciate is particularly important here. All right. The drafters of this intentionally chose that word because they wanted the courts to examine more than simple intellectual knowledge. All right, so a defendant might technically know that an act violates the law while still lacking a genuine appreciation of its significance because of the severe mental illness. For example, let's say that you have someone who's suffering from, some profound delusions. They may be able to recite that homicide is illegal while still simultaneously believing that killing is necessary to save the world from an imaginary threat. All right. So the model penal code approach, it incorporates aspects of both the Monotone rule and the irresistible impulse test. So it considers both understanding and behavioral control. Now, many legal scholars view this approach as a more realistic reflection of how serious mental illness affects human behavior. Mental disorders do not always fit neatly into categories of total awareness or total incapacity. All right. Human psychology is way more complex than that. So the substantial capacity test attempts to account for that complexity while still providing the courts with workable legal standards. All right. And as we continue through this section, you will see that the insanity law remains one of the most controversial intersections of law, medicine, psychology, and public policy within the entire criminal justice system. So now let's talk about one of the most significant developments in modern insanity law, and that is the creation of the guilty but mentally ill verdict. Okay. This concept emerged largely because people became uncomfortable with traditional insanity acquittals. All right, so public concern increased dramatically after 1981. And that's when, John Hinckley attempted to assassinate President Ronald Reagan, and he was found not guilty by reason of insanity. And we're talking many members of the public believed that he had escaped responsibility for a very serious crime. Now, whether that perception was accurate or not, the case itself sparked very widespread debate about the insanity defense and whether it had become too broad. All right, so in response, many states re-examined their insanity laws, and some jurisdictions adopted a guilty but mentally ill verdict. Now, under this approach, the jury can conclude that the defendant suffered from a mental illness at the time of the offense, but did not meet the legal definition of insanity that was required for a complete acquittal. All right, notice the distinction. A person found not guilty by reason of insanity is not considered criminally responsible under the applicable insanity standards, right? But a person found guilty but mentally ill is still considered criminally responsible and may be convicted of the offense. The difference is that the mental illness is formally recognized as a part of the verdict. So in theory, the defendant receives both a punishment and treatment, okay? Now, supporters argued that this approach would protect public safety while still acknowledging the role that mental illness played in the offense. But critics, on the other hand, questioned whether mentally ill defendants actually received meaningful treatment once they entered the correctional system. I would argue for that as well, because I would want to know that, but I digress. Now, several states have abolished the traditional insanity defense altogether. And I know a lot are surprised by this because the insanity defense receives so much attention in criminal law courses and popular media, right? But you have jurisdictions like Idaho, Montana, Utah, and Kansas, and they have very significantly restricted or eliminated those traditional insanity defenses, all right? Those states generally permit, defendants to present mental health evidence in other ways, particularly like when we're talking about intent, okay? But they don't recognize a separate insanity acquittal into the traditional sense, all right? Now, this area illustrates how criminal law often reflects more broad social debates about responsibility, mental illness, punishment, and public safety. And different jurisdictions have reached very different conclusions regarding how those interests should be balanced. Now let's talk about what actually happens procedurally when a defendant intends to raise an insanity defense, okay? Some people imagine that a defendant can simply appear in court and suddenly claim insanity at the last moment, right? In reality, though, insanity defenses are governed by very extensive procedural requirements. So remember that insanity is generally considered an affirmative defense. That means the defendant has to provide notice that insanity will be raised as a part of the defense strategy, okay? The purpose of this requirement is fairness. So prosecutors need an opportunity to investigate the claim, to gather evidence, and to prepare responses. All right. Now, courts also need time to arrange evaluations and to address expert testimony. Now, once insanity becomes a part of the case, psychiatric examinations will often follow. So mental health professionals, they may evaluate the defendant, review the records, conduct interviews, administer tests, and even offer, expert opinions regarding the defendant's mental condition at the time of the offense. So expert testimony becomes enormously important in those cases. Now, unlike many criminal trials where jurors can where they can rely heavily on eyewitness testimony, which they shouldn't, or physical evidence, insanity cases are going to involve very highly technical discussions that are going to have, like a psychiatric diagnosis, mental disorder, cognitive functioning, behavior control, things like that. So as a result, jurors may hear competing testimony from multiple experts reaching very different conclusions. One psychiatrist may say that the defendant suffered from severe psychosis that prevented meaningful understanding of reality. Another may say that the defendant understood exactly what was happening and merely suffered from a less severe mental disorder. Okay, and this creates one of the biggest challenges in insanity litigation. Jurors have they have to evaluate this complex psychological evidence despite having no professional training in psychiatric issues, psychology, psychiatry as a medicine, any of those things. Okay, now remember the defendant's burden of production. So as I already mentioned, this means that the defendant must present enough evidence to place insanity legitimately at issue. And once that threshold is met, again, additional questions will come up regarding persuasion and the specific standards used within the jurisdiction. All right. But insanity cases, they essentially become the battles between competing narratives. All right, one side is going to argue that the defendant's mental illness destroyed criminal responsibility, and the other is going to argue that no, the defendant remained legally accountable despite any mental health issues that may have existed. Now let's address one of the most common misconceptions about the insanity defense. Many people believe that a defendant found not guilty by reason of insanity simply walks out of the courtroom and goes home, and that is almost never what happens. In reality, insanity acquittals are often followed by a civil commitment proceeding that is designed to determine whether the individual remains dangerous because of mental illness. Okay, so the legal question shifts at this stage. The issue is no longer criminal guilt. The issue becomes public safety and mental health treatment. Okay. Now, it specifically points out the model penal code approach here, which generally requires commitment following an insanity acquittal. So the court will then evaluate whether or not the individual continues to present a danger to people or property. So if dangerousness remains, then continued commitment may occur within a secure mental health facility. If that person no longer presents a significant threat, then release can become, possible, at least eventually. Some defendants end up spending more time in psychiatric institutions after an insanity acquittal than they might have spent being incarcerated had they, just simply been convicted from the beginning. That reality often surprises people because public discussion sometimes portrays insanity acquittals as easy escapes from punishment. Okay. Now, the burden frequently falls on the defendant to demonstrate that release would not create an unacceptable risk. All right. So mental health professionals will evaluate progress, the treatment compliance, the stability of the individuals, and any risk factors before the court will authorize a release. Okay. The goals of commitment differ from the goals of imprisonment. So prisons primarily focus on punishment, incapacitation, and deterrence. So mental health facilities, they focus primarily on treatment and public safety. That distinction reflects the fundamental theory behind the insanity defense itself. So if mental illness eliminated criminal responsibility, treatment rather than punishment becomes the primary concern. All right. And this portion of the law reflects society's ongoing effort to try to balance compassion for mental illness against legitimate concerns regarding public protection. Now, last but not least, in regards to insanity, we need to distinguish between insanity at the time of the offense and then competency at the time of trial. And people often confuse those concepts because they both involve mental health, but they address completely different legal questions. So insanity focuses on the defendant's mental condition when the crime actually occurred, all right? Competency focuses on the defendant's mental condition during the criminal proceedings. So the Constitution requires that defendants be competent before they stand trial. Well, why is this? It's because due process demands that defendants understand what is happening and to possess the ability to assist in their own defense. So imagine trying to defend yourself against criminal charges while being completely unable to understand the role of the judge or the prosecutor or your own attorney or even just the nature of the proceedings themselves. The trial process would be fundamentally unfair. So a competent defendant must be able to understand the charges, to communicate meaningfully with their attorneys, to participate in the decision making, and they have to be able to grasp the basic nature of the proceedings. Now, if a defendant is found to be incompetent, the criminal proceedings are generally going to be suspended. So the defendant may be committed for treatment until competency is restored. But it's going to depend on jurisdiction and how they do it. But this is not a permanent status, okay? So a defendant may be competent today and incompetent later, and vice versa, okay? Some who are initially found to be incompetent may eventually receive treatment and regain, competency that is sufficient enough to proceed. Now, One thing I want to point out is that this slide also references capital punishment. And the Supreme Court has held that individuals who become insane after receiving a death sentence cannot be executed while they are incompetent. So the reasoning is that executing a person who cannot understand the punishment or the reason for it serves little legitimate purpose within the criminal justice system, okay? Competency laws reflect one of the most basic principles of fairness within the American criminal procedure. And that is, before the government can prosecute and punish somebody, that person must possess a meaningful ability to understand and participate in the process itself. Now, this right here, this diagram, kind of ties together a lot of the concepts that we've already discussed, right? And you might think of it as a slide that's kind of showing the life cycle of an insanity claim within the criminal justice system. When mental illness becomes an issue in a criminal case, the courts have to answer several different questions, and those questions often arise at different stages of the proceeding. And the first question is whether the defendant was legally insane at the time of the offense. That determination focuses entirely on the defendant's mental condition when the criminal act occurred. Okay, so courts are essentially looking backwards in time and attempting to determine whether or not a mental disease or defect affected criminal responsibility under the applicable legal standard. All right. If insanity becomes part of the defense strategy, then evaluations are conducted, experts get involved, and then evidence is going to be presented to the judge or jury. Okay. Proving insanity often requires reconstructing a person's mental state months or even years after the offense occurred. All right, and that process can be extraordinarily difficult because mental illness can fluctuate over time. Add in the fact memories fade, and then you have experts who frequently will disagree about a diagnosis and their legal significance. Okay, the next question is going to involve competency to stand trial. And again, that's a completely different issue. The court is no longer focused on what happened during the crime, but instead they're focused on the defendant's present ability to participate in the proceedings. So if the defendant cannot understand the nature of the proceedings, or they cannot meaningfully assist counsel, the trial generally cannot move forward, okay? And this is one of the most important procedural protections in the criminal justice system, in my opinion. The law recognizes that criminal proceedings lose their legitimacy if defendants cannot comprehend what is happening around them, okay? So remember that competency can change over time. So a defendant who is competent today can later regain that competency through treatment. In the same vein, a defendant who begins trial as competent may later become incompetent because of mental deterioration or other factors. And then the final stage is about the disposition after an insanity acquittal. Again, remember that not guilty by reason of insanity does not automatically mean freedom. Courts have to determine whether or not the person remains dangerous and whether commitment to a mental health facility is appropriate, okay? So what this diagram ultimately illustrates is that mental illness may affect criminal proceedings and it may affect it at multiple points. All right. So questions involving responsibility and competency, treatment, commitment, public safety, all of that stuff can arise within the same case. All right. And few areas of criminal law require courts to balance legal principles with medical evidence and constitutional protections and public safety concerns as frequently as insanity law does. Now, moving away from insanity and into two defenses that are often discussed together because they both involve situations where defendants claim they had no reasonable choice. The first is duress. So duress applies when a defendant commits a crime because another person threatens serious harm or death unless the crime is committed. So in this case, we focus on the source of the pressure, all right? So with duress, the pressure comes from another human being. So imagine someone is holding a gun to your head and ordering you to drive the getaway car during a robbery. Or imagine that a criminal organization is threatening to kill your family unless you transport illegal drugs, All right. In both of those examples, the defendant is claiming that the criminal conduct occurred because of overwhelming threats created by another person. So the law generally requires more than vague fear or generalized anxiety. The threat has to be serious and immediate, and it has to be believable. All right. The defendant must also reasonably believe that committing the crime was the only practical way to avoid the threatened harm. All right. And courts are often very skeptical when defendants claim duress because many offenders later attempt to minimize responsibility simply by blaming others. And as a result of this, judges and juries typically examine these claims very carefully. All right. Now, there is an important limitation. Simply following orders is usually not enough. All right. So throughout history, individuals who have been accused of crimes have frequently argued that they were merely carrying out instructions from superiors. All right. And modern criminal law generally it rejects the arguments that are, on that standing alone. Okay. This principle from like discussions of war crimes, the Nuremberg trials following World War II and stuff like that, this is where you see this principle kind of coming together, right? The fact that a superior ordered illegal conduct does not automatically eliminate criminal responsibility. Okay? It just does not. Now, this slide also talks about the fact that duress generally is not a defense to homicide. The traditional reasoning is that the law does not permit one innocent life to be intentionally sacrificed in order to save another. All right. So this limitation generally creates substantial debate because people disagree about what they themselves might do when confronted with threats of death or, severe harm. So duress, in essence, raises difficult questions about free will and coercion and, personal responsibility and even just the limits of human decision making when done under extreme pressure. Now let's talk about necessity. And it's closely related, but it differs in one very important way. With necessity, the pressure does not come from another person. The pressure comes from circumstances or natural forces or emergencies or some sort of conditions that are beyond the defendant's control. Okay? So think of necessity as, the lesser of evils defense. Okay? The defendant argues that violating the law was necessary in order to prevent a greater harm from occurring. All right, so let's say that there is a severe winter storm, okay? And it leaves a family stranded in a life-threatening situation, okay? Life-threatening conditions even, all right? Because it's severely cold and snowy and everything, right? So suppose that someone breaks into an unoccupied cabin in order to avoid freezing to death. Well, technically a trespass or a burglary may have occurred, all right? But the defendant may argue that violating the law was necessary to prevent a much greater harm, all right? Or let's say that you have somebody who is destroying private property because they're trying to create, the firewall or the fire break that prevents an entire community from being, attacked by the fire that's like spreading rapidly. And there's cases on this, like several of them. Again, in these cases, the argument is that a lesser harm was chosen to avoid a greater one. All right, so necessity does not require danger to human life exclusively. You have property damage and other forms of significant harm that can also create those necessity situations. But courts are generally going to require that no reasonable legal alternative existed. So if a less harmful option was available, the defense is most likely going to fail. All right? And that requirement often becomes the central issue in necessity cases. So the question is not simply whether the defendant faced an emergency, but the question is whether or not the defendant truly had no reasonable alternative other than to violate the law. Okay? One other thing that I want to point out, as you see down at the bottom, both duress and necessity are considered complete defenses when they are successfully established. So this means that acquittal can result because the law says that criminal liability should not be imposed under those conditions, okay? And these defenses reflect an important reality about criminal law. And that is that sometimes individuals will find themselves confronted with impossible situations where every available option involves some form of harm. And the law occasionally recognizes that punishing those individuals may not serve the interests of justice. Now let's talk about one of the most frequently litigated and probably widely discussed areas of criminal law, and that is self-defense. Now, this is one of the few doctrines that nearly everyone understands intuitively at some level, right? Most people believe that they should have the right to protect themselves when confronted with unlawful violence. Now, the difficult legal questions arise when courts must determine exactly how much force is justified and under what circumstances. So, at its core, self-defense is based on necessity, all right? So the defendant argues that force was required to prevent imminent harm, right? So pay close attention, though, to the word imminent. All right, the threat generally must be immediate rather than something that is speculative or might occur in the future, all right? So, for example, suppose someone threatens to attack you right now. They raise a weapon and they move toward you. Most jurisdictions would recognize that as a very different situation than someone making vague threats about what they might do next week or next month. All right? The law usually requires that the danger be immediate and that the response be necessary. Now, another important principle involves proportionality. So the amount of force that's used should generally be reasonable in relation to the threat that is faced. So if somebody shoves another person lightly during an argument, right, most courts are not going to consider a deadly response reasonable under those circumstances. Now, on the other hand, a person's confronted with like an armed attacker, they would be justified most likely in using significantly greater force. All right. Now, understand that the person claiming self-defense generally cannot be the initial aggressor. All right, so if someone deliberately starts a fight and then attempts to claim self-defense after the situation escalates, then the defense becomes much more difficult to establish. That's why you can't like poke a bear and then cry because it bites you, that type of thing. Now, it also has on here the concept of battered spouse syndrome. And this became important because traditional self-defense rules sometimes fail to account for the realities of long-term abuse. And historically speaking, courts often focused heavily just on the immediate physical confrontations, but victims of prolonged domestic violence sometimes responded to threats under circumstances that did not fit neatly within traditional self-defense models. Okay, so as courts developed a better understanding of the psychological effects of ongoing abuse, expert testimony concerning battered spouse syndrome became increasingly important in certain, cases. Now, I want to also point out here too, this also has evolved from battered wife syndrome to battered spouse because the courts did start, recognizing that men also are abused. So I do want to make that a distinction as well, because there's a case that I'd actually like to talk to you guys about at some point where this is the core of that very case, and it's out of New York. But I digress for the moment. So, the retreat to the wall doctrine. So, individuals were expected to retreat if it was safely possible to do so before they used deadly force, right? Now, the castle doctrine created an important exception, and the law generally recognized that people should not be required to flee from their own homes before defending themselves against an unlawful intruder. Now, more recently, many states have adopted the stand your ground laws, and this removes the retreat requirements in certain situations, and it permits individuals to use lawful force without first attempting to escape. Debates about self-defense law, these often reflect more broad disagreements regarding personal responsibility, public safety, firearms, individual rights, things like that. And honestly, few criminal law topics generate more public discussion than questions involving when force becomes legally justified or not. So now let's talk about the defense of others. This extends many of the same principles that we just talked about in self-defense situations. So the basic idea is relatively straightforward. If the law allows individuals to protect themselves from unlawful harm, it may also allow them to protect other people facing the same danger. However, historically speaking, that doctrine was more limited. So under common law, people were often permitted to use force only when protecting individuals with people they shared a special relationship with. Examples being like, parent and child, husband and wife. Okay. And the reasoning was that these relationships created specific duties of protection. Now, modern law generally takes a more broad approach. Most jurisdictions now recognize that individuals may use reasonable force to protect another person from immediate unlawful harm, even when no special relationship exists. All right. So think about situations where someone witnesses an assault that's occurring in public. So suppose an individual observes, somebody being violently attacked and they intervene to stop the assault. Modern self-defense principles will often permit reasonable force under those circumstances because the law recognizes society's interest in protecting innocent victims. Okay. Now, the same concept of necessity and proportionality still apply, though. So the force used must generally be reasonable in light of the threat that's faced by the person that's being protected, okay? So the defense of others cases, they can be messy, all right? They can become complicated because the intervener may not fully understand the situation. Imagine arriving in the middle of a fight without knowing who initiated the conflict. So someone attempting to help may end up mistakenly intervene on behalf of the aggressor rather than the victim. Those factual uncertainties will often become the central issues when it comes to trial. Okay? But just recognize that the defense of others, this reflects a very important societal value. Criminal law does not simply permit people to protect themselves. In many circumstances, it's also going to recognize the legitimacy of protecting innocent individuals who are facing immediate danger as well. Now let's talk about the defense of property and habitation. This is very closely related to self-defense, but it operates under somewhat different rules. People often assume that people have the same right to use force to protect property that they have to protect themselves. The law, however, generally treats human life as more valuable than a property interest, okay? And the distinction is important. The law recognizes a person's right to protect their possessions, land, homes, and other property from unlawful interference. However, the amount of force that can be used is usually more limited in situations that involve, threats to human life or bodily safety, right? So imagine someone attempting to steal a bike from a front yard. In most jurisdictions, they would permit reasonable efforts to stop the theft, right? But you should recognize that shooting the thief to protect the bike would raise very different legal concerns, all right? The law generally expects the force used to remain proportional to the interest that's being protected, okay? And deadly force is typically not permitted solely to protect property. The principle surprises a lot of people when they first encounter it because they often feel very strongly about their property rights, okay? But criminal law traditionally places, again, a much higher value on preserving human life than on protecting material possessions, all right? Now, we need to distinguish also the defense of property from defense of habitation. And historically, homes have occupied a special place within the law. The home is not merely property. It's also a place where people sleep and they raise families and they expect personal security, okay? Because unlawful intrusions into a home create potential threats to occupants, courts often permit a more broad defensive action in habitation cases than in ordinary property disputes, okay? Now, even when homes are involved, courts still examine whether force that was used was reasonable under the circumstances. Modern cases frequently involve very difficult factual questions regarding what the homeowner reasonably believed at the moment the force was used. Okay, judges and juries, they often evaluate events that unfolded in seconds while considering what information was actually available to the person who was making that decision. And by the way, a really good case for this, if you want to look up something, it's called Catco v. Briney, and it's Katko. Very good case for this type of thing in terms of the difference between defense of property versus defense of habitation, because in that case, they had a second property where they had a spring-loaded gun that was aimed toward the door. So if somebody opened the door, they would be shot. It was in a bedroom, and somebody did, and they did die. Anyhow, but the point of it was they made the determination that if you didn't live there, you could not be protecting your property in that particular manner. But that's food for thought. Again, it's just a case, a very famous case, if you want to look it up, Catco v. Briney. Now, as it shows here, force is generally not considered reasonable when other effective means of protection are readily available, right? So this reflects another recurring principle throughout criminal law. Defensive force is usually justified because it's necessary. When necessity disappears, though, the justification will weaken as well. All right, so ultimately, defensive property rules attempt to balance, two important interests. We have society's desire to protect ownership rights, and then society's desire to also avoid unnecessary violence. Now let's talk about the imperfect self-defense. And this is a concept that many initially find confusing because it kind of sits somewhere between successful self-defense claims and no defense at all, okay? So a successful defense claim generally results in a complete acquittal because the law concludes that the defendant's actions were justified, right? But an imperfect self-defense is different. So under this doctrine, the defendant honestly believed that force was necessary, but that belief was unreasonable or otherwise legally insufficient, okay? So this is where we're going to focus on the defendant's mental state. So the law recognizes that a person may genuinely fear danger, okay, and act because of that fear, even when the facts do not fully justify a complete self-defense claim. All right, so for example, imagine someone mistakenly believes another person is reaching for a weapon, right, and responds with deadly force. If the belief was genuine but objectively unreasonable, then some jurisdictions may recognize it as an imperfect self-defense. So the defendant doesn't receive a complete acquittal because the force was not legally justified. However, the defendant's mistaken belief can reduce the criminal liability because it affects the mental state that's accompanying the act. I hope that makes sense. Now, this slide also explains that the imperfect self-defense functions as a mens rea defense. You should remember from earlier chapters that mens rea concerns the mental component of criminal liability. So if the defendant acted under an honest belief that defensive force was necessary, then that belief may undermine the malice required for certain homicide offenses, not defenses. And as a result, a charge that might otherwise qualify as murder can be reduced to voluntary manslaughter or involuntary manslaughter, okay? The doctrine reflects the law's recognition that human beings sometimes make very tragic mistakes under stressful and rapidly evolving circumstances, all right? But the law does not necessarily excuse those mistakes completely, but it may treat them differently from deliberate, malicious killings, all right? So you should note that the imperfect self-defense, it's generally going to apply only in homicide cases. All right. The doctrine was developed primarily as a way of distinguishing between intentional murder and killings resulting from, some sort of mistaken perception of danger. All right. The imperfect self-defense demonstrates how criminal law often operates in kind of shades of gray rather than simple categories of just guilt and innocence. And courts frequently have to evaluate not only what happened, but also what the defendant honestly believed was happening when the events occurred. Now let's talk about arrest and the use of force associated with arrest situations. Historically, individuals sometimes possessed a common law right to resist unlawful arrest. The theory was that citizens should not be forced to submit to improper exercises of governmental authority. All right, now modern law has moved away from that approach. Today, most jurisdictions prohibit resistance to arrest even when the person believes that the arrest is unlawful. Instead, the legal system generally expects disputes regarding the legality of an arrest to be resolved later through the courts rather than through physical confrontations on the street. Now, this change reflects practical concerns. Lawmakers recognize that allowing people to decide for themselves whether an arrest is lawful often increase the likelihood of injuries to suspects, officers, and bystanders. Okay, law enforcement officers, are allowed to use reasonable force when making arrests, but the key word again is reasonable. All right, officers are not permitted unlimited force simply because an arrest is occurring. All right. And courts evaluate the circumstances, the threat, posed by the suspect, the severity of the offense, and the level of resistance involved. And so this slide, it specifically talks about Tennessee versus Garner. This case significantly limited the use of deadly force against fleeing suspects. So before Garner, some jurisdictions permitted officers to use deadly force whenever a felony suspect attempted escape. The Supreme Court rejected that broad rule and held that deadly force generally may not be used unless the suspect presents a significant threat of death or serious bodily harm. Okay? Think about how important that decision was. The court essentially concluded that the government's interest in apprehending a suspect doesn't automatically outweigh the suspect's constitutional interest in life and bodily integrity. Now let's talk about arrests by citizens, okay? Under certain circumstances, private citizens may make arrests when they possess probable cause to believe that a felony has occurred. So those rules vary significantly from state to state, and many jurisdictions impose very specific limitations designed to prevent abuse, okay? Citizen arrest situations often create very substantial legal risk because private individuals do not possess the same training, the same authority, or the same legal protections that are available to law enforcement officers, okay? And the broader lesson from this section is that force used during arrest, they remain subject to legal limits. So whether the actor is a police officer, a private citizen, or a person being arrested, again, the law is going to continually attempt to balance public safety, individual rights, and the need for effective law enforcement. Now let's talk about infancy. This is a defense that's based upon age and the ability to form criminal intent. So remember that criminal liability generally requires a guilty mind as well as a guilty act. And historically, courts recognized that very young children often lack maturity, judgment, and understanding that's necessary to form the mental state that's required for criminal responsibility. Now, under common law, children under the age of 7 were conclusively presumed incapable of committing crimes. In other words, the law just simply assumed that children that young lack the ability to form criminal intent. That reflects a common sense kind of understanding of child development. Most young children do not possess the same ability as adults to appreciate consequences, to understand legal rules, or to exercise mature judgment. The common law created a different rule, though, for children between the ages of 7 and 14. From that age group, the law presumed incapacity, but the presumption could be overcome if the prosecution demonstrated that the child understood the wrongful nature of the conduct. This is a rebuttal presumption, okay? This has created a case-by-case analysis, essentially. So courts would examine the child's intelligence, their maturity, their experience, and their understanding of the specific conduct that is involved. Now, today the legal landscape looks somewhat different because specialized juvenile justice systems have largely replaced the older common law approach. All right, and modern juvenile courts generally possess exclusive jurisdiction over most criminal behavior that's committed by minors. The underlying philosophy differs significantly from the adult criminal system. So rather than focusing primarily on punishment, juvenile courts traditionally emphasize rehabilitation, education, treatment, behavioral correction, all of those things, okay? And that distinction reflects society's recognition that children are still developing intellectually, emotionally, and psychologically. All right. But serious offenses sometimes create exceptions. In certain circumstances, juveniles can be transferred to adult court and prosecuted as adults. Those decisions often depend on factors like age, criminal history, and the seriousness of the offense. But the broader principle it still remains relatively consistent. Criminal law generally recognizes that children differ from adults in meaningful ways, and those differences affect how responsibility, punishment, and rehabilitation should be approached. Now let's talk about intoxication, which is a defense that generates significant public misunderstanding. Many people assume intoxication automatically excuses criminal behavior, and that is not the case. Voluntary intoxication is often a very limited defense. The law generally takes the position that the individual who voluntarily consumes drugs or alcohol should ordinarily bear responsibility for the consequences of that decision. Now, let's say there's a caveat here, okay? Intoxication sometimes affects criminal liability because it can interfere with the formation of the mental state that's required for particular offenses. So go back to our earlier discussions about mens rea. Certain crimes require proof of highly specific intent. So if intoxication prevents formation of that specific mental state, the prosecution may have difficulty proving every required element of the offense. So, for example, imagine a crime that requires proof that the defendant acted with a particular purpose or an objective. Okay? A defendant may argue that severe intoxication prevented formation of that specific intent. Now, even when successful, voluntary intoxication just typically reduces liability rather than eliminating it entirely. Okay? And many states have become increasingly reluctant to recognize voluntary intoxication defenses because of concerns that individuals might attempt to use self-induced impairment as an excuse for criminal behavior. But let's talk about involuntary intoxication because this is treated very differently. Involuntary intoxication occurs when a person becomes intoxicated without knowingly or willingly choosing that condition. So, for example, someone may unknowingly, consume a substance or experience an unexpected reaction to a medication or be drugged without consent. Under those circumstances, the law is going to be more sympathetic because the defendant did not voluntarily create the impairment. So if the intoxication is sufficiently severe, then criminal liability can be eliminated entirely. Now, you should recognize that successful involuntary intoxication claims, they are so rare. Again, because courts require substantial evidence that shows the involuntary nature of the intoxication plus the effect that it had on the defendant's mental state. Okay? Intoxication defenses, though, overall, they reveal another recurring theme in criminal law, and that is that courts are often trying to distinguish between conditions that people voluntarily create and conditions imposed upon them by circumstances that are beyond their control. Now let's talk about mistake. This might seem very simple at first, but actually involves a few important distinctions. So the law recognizes two primary categories of mistake. You have mistake of law and mistake of fact. All right. This is a basic principle that has existed for centuries. Generally speaking, and you will hear me say this a million times over throughout all the courses, ignorance is not a defense of law. Okay. So if someone claims they did not know a particular statute existed, in most situations, that argument is not going to prevent criminal liability. And the reason is practical, okay? If ignorance of the law automatically excused criminal conduct, then nearly every defendant could simply claim unfamiliarity with whatever applicable statute, Okay? The legal system could not function effectively under those circumstances. There are, though, some limited exceptions. For example, if the government fails to make a law reasonably available to the public, then you have fairness concerns that come up. Okay? In the same way, courts will occasionally recognize defenses where defendants reasonably relied on, official legal interpretations that later proved to be incorrect. So, like if their attorney told them something and they relied on it and it was wrong. Okay? Those situations, though, are unusual, but they demonstrate that even long-standing legal principles do sometimes have exceptions. Now, mistake of fact is different. Mistake of fact serves as a defense when it prevents the formation of the required mental state. Okay, so for example, if you have someone who is taking another person's identical looking suitcase from baggage claim at the airport, and they honestly believe it's their own. The person intended to take the suitcase, but they did not intend to steal the property that belonged to someone else. So the mistake affects the defendant's mental state, and therefore, it defeats an essential element of the offense. All right. But the mistake has to be honest and made in good faith. Okay. Courts will spend a significant amount of time evaluating whether a claimed mistake was genuinely reasonable or whether it was simply, an excuse that was developed after the fact. But mistake defenses, they illustrate the importance of mens rea throughout criminal law. Liability often depends not only on what happened, but also what the defendant honestly believed was happening at the time. Now let's talk about entrapment. I think this is one of the most interesting defenses in criminal law because it focuses not on the defendant's conduct alone, but also the behavior of law enforcement. At its core, entrapment occurs when government agents encourage, induce, or even persuade a person to commit a crime for the purpose of prosecuting that person afterwards. Okay? Let me go ahead and put this out there. Undercover investigations, they're not automatically entrapment. Law enforcement officers will routinely pose as drug buyers, sellers, gang members, online predators, participants in criminal activity, right? And the courts will typically permit those tactics because officers are often investigating individuals already willing to commit crimes, all right? The critical question is whether the government merely provided an opportunity to commit a crime or whether the government actually created the criminal conduct. For example, let's say that you have an undercover officer posing as a buyer in a drug investigation. If a suspect readily agrees to sell drugs, courts will generally view that as providing an opportunity. All right? Now, imagine that an officer repeatedly pressuring a law-abiding citizen for months, making emotional appeals, offering extraordinary incentives, and refusing to accept repeated refusals until the person just finally caves and they're like, okay, fine, I'll do it. All right? And they commit a crime that they otherwise would not have done had this whole thing not occurred, right? That situation begins to look more like entrapment. All right, so the defense exists because society wants law enforcement to detect and prevent crime, not to manufacture it. All right, now it does mention down here perjury traps. These are situations that involve investigations where government officials allegedly place individuals in circumstances designed primarily to create opportunities for false statements rather than to investigate independent criminal conduct. All right. Now, entrapment is a relatively modern defense compared to many of the doctrines that we've already, been talking about. This defense developed as courts increasingly confronted very sophisticated undercover investigations and needed rules defining appropriate limits on the government conduct. So these cases raise important questions about fairness. The issue is not simply whether the defendant committed the act. The issue is whether the government involvement became so significant that criminal liability should not be imposed. Now, there are two primary approaches that the courts will use when determining whether or not the entrapment occurred. The first is known as the subjective test, and it's an approach that's used by federal courts as well as most states. Now, under the subjective test, the central question becomes whether or not the defendant was already predisposed to commit the crime before the government involvement occurred. Focus on the word predisposed, okay? Courts applying this test ask whether the defendant was an otherwise innocent person who was persuaded into criminal conduct, or like whether the defendant was already willing and ready to commit the offense when this opportunity arose, okay? Because predisposition becomes important. It becomes important because evidence regarding the defendant's background, their prior conduct, their criminal history, they may all be introduced, okay? For example, if prosecutors can demonstrate that a defendant was actively seeking opportunities to commit some sort of similar crime before encountering the undercover officers, then the entrapment defense becomes much more difficult to establish. The second approach is known as the objective test, and this approach shifts attention away from the defendant and focuses instead on the conduct of law enforcement. So rather than asking whether the defendant was predisposed, courts examine whether government behavior would likely cause an ordinary law-abiding person to commit the offense. Okay? The objective approach reflects a very different philosophy. It focuses primarily, the subjective test focuses primarily on the defendant, whereas the objective is focusing primarily on the government. Now, the model penal code generally favors this objective approach because its drafters were concerned about improper law enforcement tactics but regardless of the defendant's prior history. Okay? And honestly, the debate between the two approaches kind of reveals a deeper disagreement about the purpose of entrapment defenses itself. Should the defense exist primarily to protect innocent people from government inducement? Or, should it exist primarily to limit improper government conduct? Different jurisdictions answer that question differently, but what remains consistent is the underlying concern that criminal investigations should uncover crime rather than create it. Now let's talk about two classic factual defenses. We have alibi and consent. An alibi is the most straightforward, defense in criminal law. The defendant claims that he or she could not have committed the crime because he or she was somewhere else when the crime occurred. All right. So an alibi does not excuse criminal conduct. Instead, it directly challenges the prosecution's version of events. For example, suppose that prosecutors say a robbery occurred at 8 o'clock in Atlanta, right? If the defendant can show that they were attending a conference in Denver at that exact same time, then the prosecution's theory becomes impossible. All right? The defense, therefore, attacks one of the most basic questions in any criminal case, and that was the defendant actually present? Now, because alibi defenses can significantly affect trial preparation, defendants are generally required to provide advance notice when they intend to rely on an alibi. This allows prosecutors an opportunity to investigate the claim and to evaluate any supporting witnesses or evidence. Okay? Now, consent. Consent can serve as a defense when the alleged victim voluntarily agreed to the conduct in question. All right? For example, consent can defeat certain theft offenses because property was transferred voluntarily rather than taken unlawfully. All right? Now, in the same vein, consent often becomes very important in cases involving sexual offenses where the central dispute concerns whether permission was given. All right? Consent has its limits, though. The law does not permit individuals to consent to every form of conduct. For example, consent generally is not recognized as a defense to statutory rape because the law has determined that minors lack legal capacity to provide valid consent. All right? Similar limitations exist in offenses involving like incest, child molestation, and homicide. All right? You can't agree to have someone kill you. And honestly, consent cases frequently become very complicated because courts have to determine whether or not the consent was knowing, was it voluntary, were they informed, and was it legally valid. All right. But both the alibi and consent, they focus heavily on factual disputes. Rather than arguing that criminal conduct should be excused, these defenses challenge the prosecution's ability to prove the essential elements of the offense itself. Now let's talk about the statute of limitations. This places time limits on criminal prosecutions. You should think of a statute of limitation as a legal clock, and once that clock expires, prosecutors generally lose the ability to bring charges for the offense. At first glance, that might seem strange. If a crime occurred, why should the passage of time matter? All right, again, it goes back to that whole concept of fairness, and we'll add in reliability. Because as years pass, memories fade, witnesses disappear, they die, evidence deteriorates, and records become lost. So the legal system recognizes that defending against very old accusations becomes increasingly difficult. So as a result, legislatures establish these deadlines within which prosecutions have to begin their case, okay? The length of the limitation period generally depends upon the seriousness of the offense. So less serious crimes often have shorter limitation periods. More serious crimes generally have longer limitation periods. Now, the clock usually begins running when the offense occurs, okay? However, certain events can stop or suspend the running of time, all right? And that is what we call tolling. Tolling comes up in other areas of law as well, just so you know that. So, for example, if a defendant flees the jurisdiction and remains unavailable for prosecution, some jurisdictions will suspend the limitation period until the defendant can reasonably be brought before the court. Another important principle involves lesser and greater offenses. So suppose that the limitation period expires for a lesser offense, but it remains open for a more serious one arising from that same conduct. In that situation, prosecution for the greater offense can still proceed. Okay. A good example of that would be like robbery, where it is your larceny plus force, right? You can still be prosecuted for that, but the statute of limitations for the larceny itself is going to be much lower. Now, let's also talk about another important exception in criminal law, and that is that murder generally has no statute of limitations. And that reflects society's judgment that some offenses are so serious that the passage of time should never completely eliminate the possibility of prosecution. And modern DNA testing has made this issue particularly significant. Cases that remained unsolved for decades are now being reopened because we have these technological advances that allow investigators to identify suspects long after the crime has occurred. Okay? And ultimately, statute of limitations represents a balance between society's interest in prosecuting wrongdoing and the defendant's interest in receiving a fair opportunity to defend against criminal accusations. Now, before we conclude this chapter, I want to discuss an ethical issue that kind of strikes at the heart of the criminal justice system, actually all systems, and that's conflict of interest, okay? Your slide here calls it playing both sides of the fence. And honestly, that phrase kind of captures the concern quite well. All right. The criminal justice system depends heavily on public confidence. So people have to believe that prosecutors, defense attorneys, judges, everybody else, that they're acting fairly and ethically. So when conflicts of interest arise, that confidence can very quickly go away. All right. Prosecutors occupy a unique role within the legal system. So unlike private attorneys, prosecutors do not simply represent individual clients. Their obligation is to seek justice, and that means that they have a duty to pursue criminal cases fairly. They are to disclose required evidence and to exercise discretion in a manner that is consistent with ethical responsibilities. So because of that role, prosecutors must avoid situations that create either actual conflicts of interest or even the appearance of impropriety. So imagine a prosecutor being assigned to a criminal case involving a former client. Even if the prosecutor believes complete objectivity is possible, members of the public may reasonably question whether personal relationships could influence decisions involving charging or plea negotiations or evidence disclosure or even sentencing recommendations. Okay? Now consider a situation involving maybe a former law partner, close friend, family member, professional associate. Again, the concern is not necessarily that misconduct will occur. The concern is that the appearance of favoritism or bias may undermine confidence in the fairness of the proceedings. Okay? And appearances matter greatly in the legal profession. The justice system cannot function effectively if the public believes that legal outcomes are influenced by personal relationships rather than legal principles and evidence. That's why ethical rules often require recusal. Now, recusal simply means stepping aside from a case where a conflict exists or when participation could reasonably create questions regarding impartiality. All right? Recusal is intended to protect everyone involved. It's protecting, the defendant's right to a fair trial, the integrity of the prosecutor's office, the legitimacy of the court system, and even protects, public confidence in the administration of justice. Now, throughout this course, we have repeatedly discussed statutes and constitutional provisions and defenses and criminal procedure and substantive criminal law, right? But none of those rules matter if the public loses faith in the fairness of the people responsible for enforcing them. Okay? And that's the broader lesson of this chapter's ethical discussion. Legal professionals must constantly evaluate not only whether they can participate in a matter, but whether they should. All right, ethical decision making often requires stepping away from situations where personal interest, prior relationships, or professional obligations could compromise or appear to compromise the impartial administration of justice. And as future legal professionals, that responsibility will belong to you as well. Okay? The integrity of the legal system depends on not only knowing the law, but also on recognizing when ethical obligations require personal restraint, transparency, and accountability. All right. Now, as we wrap it up, just kind of take a moment to appreciate how different this material is from a lot of what we have studied previously. Earlier chapters focused heavily on defining crimes and identifying the elements that prosecutors have to prove. But this chapter shifted our attention towards circumstances that may excuse or justify or even reduce criminal liability. We talked about insanity and competency and duress and defense of others and self-defense and all kinds of different things. And what ties all of those doctrines together is a common question. And that is, when should the law hold a person criminally responsible? And that question is often much more difficult than determining whether or not an act occurred. So criminal law is not simply a system of punishment. It is a system that's designed to evaluate intent, fairness, responsibility, mental state, coercion, necessity, justice, all of it, right? So the defenses that we studied throughout this chapter remind us that the legal outcomes frequently depend upon context. So two people may commit similar acts and yet face very different legal consequences. And that's because the surrounding circumstances differ dramatically. So as we move forward, keep these defenses in mind because they're going to appear repeatedly throughout criminal procedure. All right, so whether you ultimately work in prosecution, defense, law enforcement, corrections, whatever, all right, understanding criminal defenses will help you to evaluate cases more critically and more fairly. And perhaps even more importantly, just remember that every criminal case involves more than a criminal act alone. It involves human beings and complicated circumstances, and the legal system's ongoing effort to balance accountability with justice. I use effort loosely there. I'm all for judicial reform, but that's a whole nother story for another day. Anyhow, that's it. Please let me know if you have any questions. Bye.